Ladies and gentlemen, distinguished guests, good afternoon. Good afternoon today, Thursday, May the 11th, and on behalf of Lawyers for Lawyers, the Amsterdam Bar Association, I welcome you here all in Amsterdam at the Rode Hoed. My name is Donatello Piras. I will be your moderator this afternoon for two important tasks. The first one is we have a schedule, 2 hours of seminar, and of course, afterwards, subsequently, we also have an informal part, and I would like you to attend also that part. And that means that I'm kind of in charge of the time schedule, but I'm also in charge of giving you the floor and the word if you want to. We will use an interactive system to lower the threshold, and those two tasks are there. Today we're here together to talk about lawyer-client confidentiality in a digitalized society. And this digitalized society is, of course, nothing new, but when it comes to the very important term that in your world, of course, is crucial, there are a couple of things that lower the threshold for clients in the digitalized society. But on the other hand, there are a couple of disadvantages. I will call them disadvantages as for now. And we have invited a couple of people here, panelists, to maybe illustrate that there is also insight on that. And of course, I would like to kindly invite you all to participate in this discussion that we will have in this conversation here on stage. There is a live stream, so I would like to welcome all the people that are virtually with us today or the day after today, tomorrow, and so on, because it will be registered. We have a Twitter handle, so if you want to share it on social media, the hashtag is L4L Award 2023. And if people want to tweet or use it on Instagram, please feel free so. And of course, why award? Because the program is divided in two parts. And the first part, it's the part where, like I said, we have the panel discussion with our distinguished panelists. And subsequently, in the second part, after a very short break, is the part where, after a few important opening remarks, there will be the Lawyers for Lawyers 2023 award ceremony, a very important part, a festive part, of course. Our laureate there will speak in Spanish, but we will have subtitles on the screen, so that's taken care of, and the rest of the seminar will be held in the English language. So if you have some questions, please try do your utmost to do it in English. And of course, the Dutch lawyers can earn the so-called PO-punten by physically attending it today. And of course, I would like to have a warm welcome for the speakers, the members of the independent jury of the Lawyers for Lawyers Award, Chair Egbert Meijer, there he is, and Claudia González, our laureate. Where is she? I saw her previous. She is somewhere. I know she is in the house. And of course, Lyudmila Kazak, the laureate from 2021. For now, before I would like to start by introducing the interactive system, I would like to give the floor to Jacqueline Schaap, the Dean of the Amsterdam Bar, and of course, Irma van den Berg, representing Lawyers for Lawyers, with a big round of applause for both. There you go.
Good afternoon. Don't worry, I'm not going to speech. I will leave that up to the speakers who will be after us. They are far more interesting what I will have to say as president of the Bar Association of Amsterdam. I'm just here to welcome you. So welcome to all of you. We're very happy that you're here. The Amsterdam Bar is very happy to host this seminar together with Lawyers for Lawyers this week, the week of Justitia. For the past few years, Lawyers for Lawyers seminar was always, or is always, a very important part of Justitia, and I think rightly so, because an event with the name Justitia should pay attention to Lawyers for Lawyers and what it stands for. And therefore, I give now the floor to Irma van den Berg, President of the Board of Lawyers for Lawyers.
Welcome everyone here in the Rode Hoed and via live stream at this very special event. For lawyers, this is sort of the most important day every 2 years. All over the world, lawyers face grave risks and are subject to violations of their rights. And the issue is not getting less serious. Every year, Lawyers for Lawyers receives more and more requests for support, and the amount of work for lawyers at risk is ever increasing. Lawyers are being intimidated, arrested, detained, convicted, and sometimes even murdered for doing their job. And we know that it is very important to keep the issues that they face on the agenda and to discuss these issues in public. We need to make visible what is happening to them, and we want to show our solidarity. And this is what we want to do today as well, at this event. Of course, I want to give a warm welcome to Claudia as well, and also to her friend Evelyn, the laureates of this afternoon. We are going to honor and celebrate her very important and very courageous work, as you will hear later. And also, I want to welcome our panelists of today, Muriël Rosing of Stibbe, the Netherlands, Salah Hammouri, French-Palestinian lawyer, and Mr. Pietrzak, I always have difficulty with your name, I'm sorry, the president of the Bar of Warsaw. I hope we will have a very fruitful and interesting discussion today. I think the topic, lawyer-client confidentiality in a digitalized society, is very important. And it is something that lawyers face everywhere, that they risk this right having violated. I wish you all a very good afternoon, and I hope to speak to you later. Thank you.
Thank you so much. Thank you so much. Yes, Lawyers for Lawyers, like we all might already know, defends the right to practice law freely without fear of persecution for every lawyer in every corner of the world, not only here in the Netherlands. And today we're here together to talk about the central topic of today, being lawyer-client confidentiality in a digitalized society. We have invited lawyers who have knowledge about or experience with breaches of the lawyer-client confidentiality. The organization received previously a letter from a Dutch NGO with the request to cancel an invitation to one of the speakers today because of accusation of connections to a so-called terrorist organization. The organization decided to not honor this request. Lawyers that seek the support of Lawyers for Lawyers do often face unsubstantiated charges of terrorism or other crimes. It is a methodology often used to silence lawyers throughout the world. And the seminar today is about the topic of lawyer-client confidentiality. Anybody, of course, today who wants to ask questions or have a conversation about the invitation policy is welcome to talk during the informal moments. We have breaks, we have a reception afterwards to the chair of our board during the break. And Irma is, of course, here to hear everything. During the seminar, I would like to keep on topic. I hope you understand that, and I will. And we also like to hear from you. And for this, we are working with the interactive voting system. And therefore, you will need your smartphone because we will use Mentimeter for the questions. And I have a couple introducing questions for you. So if you switch to Mentimeter right now and you grab your smartphone, you can scan the QR code that is on screen right now. That's the easiest way. Then you slide easily into the system. And if you hate QR codes or you're not familiar with them, the other method is simply go to your browser. That's the left way. Go to your browser, go to menti.com, enter the code that is stated here, 1455 6285, and then the same thing will happen. You will slide into the system. In the page that you will land, there's not much you can do besides sharing likes or love. And likes are the majority right now. Um, and I see some cameras still, so I'll give you all the opportunity, of course, to participate. Of course, should you have a question and you want to raise your hand, then me or one of my colleagues will step to you with the microphone. That is important because we have a live stream. If it is not amplified with a microphone, you are not it's impossible to hear you on the live stream. So we have had and prepared a couple of introducing questions for you. The first one is an easy one. How did you get here today? Just to get into the rhythm. By bike, Amsterdam lawyers, vast majority. We have people by train, we have people by car. How on earth? Oh, that's true. Then, yes. Then me too. Perhaps. By plane, of course, because we have international guests. By foot, 20%, very healthy. And there's another category. I won't dive deep into that. All right, let's dive into the topic of the day. How do you rate, personally, the global level of confidentiality on a global scale? So that's the average, of course, not only taking into account the country that you might work for as a lawyer or in, but what is for you can see on a scale from 1 to 10. Let me explain that. It's not the Likert 5 scale, it's a 10 scale. How do you rate the global level of confidentiality right now? And the average right now, with more than 90 people, so I think it is representative for the group that is here actually, is a 4.7, which in my school years was insufficient. I won't say a lot about it right now, but of course, as a starting point for our panel discussion later on, we can make a mental picture of this slide. And finally, what are your expectations for this afternoon, for today? You freed your agenda to be here, which we appreciate very much. Also, of course, all the people virtually, but I can't see you, but happy with you as well. But also all the people that freed their agenda to be here this afternoon. People of all generations, actually, experienced lawyers, and for as long I can see, also lawyers that just started their hopefully great careers, and that is good to see. So the expectations for today are a beautiful speech, information, discussion, inspiration, support, inspiring, sharing experience, leuk. I hope so for you. The panel, knowledge, pay open to, thanks for your honesty, um, and so on and so on. So I think inspiration, learning, and support are the most important words, and it is good to know, and also the discussion. And please, you are part of the discussion as well. So allow me, ladies and gentlemen, to first introduce the panel. And after the panel, I will introduce them shortly to you. Please welcome our panelists for today. Julia Smakman, Program Assistant at Lawyers for Lawyer. Mikolaj Pietrzak, the Dean of the Warsaw Bar Association. Salah Hammouri, Palestinian-French lawyer from the OPT. And Muriël Rosing, lawyer from the Netherlands at Stibbe. With a background of applause, please, here on stage. I'm blocking you. All right. It's okay. No, well. And this is the better position. Hello, good to have you all here. Let me start by briefly introducing you with one or two personal questions. And Julia, I would like to start with you. Program assistant at Lawyers for Lawyer and also a researcher. So what do you do on a daily basis? And then we will come to the next question.
Thank you for that question. So on my daily basis, I think I divide my time between working for Lawyers and doing research. I'm also still studying at the moment. So my research interests are mostly between the overlap of human rights and technology, which is also why I've been writing this report for Lawyers and why I pushed to write this report within our organization, because I think this is a very key issue for lawyers worldwide and happens to overlap perfectly with what I do in my
and
other
we will talk. I will give you a few minutes further on in this program, actually subsequently after this introduction, to maybe elaborate a little bit more about the content of this report that I think it came out 2 days ago. It's fresh. All right. Then Julia, this is what you do on a daily basis. What is actually the connection that you have with today's topic?
Yeah, so as I stated, my primary academic interest is human rights and technology and digital rights. But of course, this is also informed by the work that I've been doing with Lawyers for Lawyers for the past 2 years. And I've spoken to many lawyers in the past 2 years from different countries around the world, different continents, who are operating in different legal systems, different situations for the rule of law. And we see that very often when I spoke to them, I would always ask them about lawyer-client confidentiality as well, because that's one of the things, of course, that we cover in our work.
Yes.
And I see that actually this issue, as we will discuss for the next hour,
Yeah.
that this is something that comes up very regularly, and this is something that's maybe not seen generally as a trend, but that is very important and it is going on a global scale. So I think it's conversations that I've had over the past years, all those bits, and then also my academic interest combined into this report.
All right. Thank you so much. Thank you for being here. Let me proceed with Mikolaj Pietrzak, the Dean of the Warsaw Bar Association. Good to have you here. And of course, I could have numerous other job titles after your name, of course, but could you maybe briefly explain what are your experiences in the field of work that you have done in well, let's say the last 10, 15 years?
Thank you. I always enjoy listening to people try to navigate my last name. So good job.
Maybe that's a good. Maybe it's a good example. Maybe one time we pronounce it correctly, and then everybody could try to.
You did an excellent job. I just like to thank Dekan Schap and President Van der Berg for the invitation. It's a great privilege to be here with you all today. I have several hats on. I think the two relevant ones are that of a criminal lawyer, a human rights lawyer, trial lawyer in Poland, and that of the Dean of the Warsaw Bar Association. And these two roles put me in a situation where I'm dealing with client-lawyer privilege and, in fact, threats or violations of client-lawyer privilege on, regrettably, a weekly basis, which I'm very sad to be considered an expert regarding violation of client-lawyer privilege. I'd rather not have the experience that dictates that status.
I understand. And so actually your connection with the topic that we're discussing today is that the breaches are on a weekly basis, and therefore you accepted also the invitation of the seminar.
Well, since I became the Dean of the Warsaw Bar, which is quite some time now, but we've registered over 400 cases of either threats or express violations of client-lawyer privilege just in the Warsaw appellate area, which is not all of Poland, which is absolutely an extraordinary thing. And it goes hand in hand with another topic, which I spoke some time ago about here, which is the violations of the rule of law, the independence of the judiciary. So these phenomena tend to go hand in hand.
We will have the occasion, of course, in, let's say, the next 50 minutes of elaborate that furthermore. Let me proceed with Salah Hammouri. What is your story, Salah?
Thank you. In the beginning, thank you, the Lawyers for Lawyers, for the invitation and all your efforts in organizing this panel and highlighting lawyers' rights in the digitalized society. It's an honor and a privilege for me to be speaking here among esteemed colleagues. My name is Salah Hammouri. I'm a French-Palestinian lawyer and a human rights defender and a former political prisoner. I was born in Jerusalem to a Palestinian father and a French mother, having been incarcerated in the Israeli occupation prison for 9 years. From the age of 16, I was keen to get on with my life, study, have a family, and catch up on the years that the occupation authorities has taken from me. Little and did I realize my release was only the start of an ordeal in which I was to become a testing ground for Israel's escalating and ceaseless attacks on Palestinians. I was subject to several administrative detention, meeting without charges or trial, And based on secret information, I had travel bans, restriction on movement, residency and health insurance revocation, deportation of my family, phone tapping using Pegasus spyware, and extremely psychological and economical pressure. Most recently, in March 2022, I was held from 9 months under administrative detention without charges or trial. When my last administrative detention order expired on the 18th of December 2022, I was unlawfully forcibly deported to France under the breach of allegiance to the occupying power. Uh, I enrolled in university and graduated from law school and immediately started working with Al-Damir Prisoner Support and the Human Rights Association as a field researcher in Jerusalem, documenting the systematical arbitrary arrests of Palestinian children. During the time, I also practiced law for 2 years, allowing me to gain my Palestinian Bar Association license. Later, I became a lawyer at Ad-Damir, representing Palestinian prisoners and detainees in the Israeli military courts.
That's a mouthful, and we're happy that you're here. Thank you. And we will furthermore discuss and maybe illustrate also the topics that we're going to discuss today also by your experiences. Thank you, Salah. Let me proceed with Muriël Rosing from the Netherlands, from Stibbe. What is actually your connection with the topic that we're discussing today?
My connection with this topic, with legal privilege, is that maybe by way of background, I'm a criminal defense lawyer at Stibbe. I'm specialized in corporate crime, so I defend corporates and executives. And in 2016, we were engaged by a company and its executives to assist and defend them. They were considered a suspect in a criminal investigation. And in the course of that investigation, it became clear, we found out that our email correspondence, our privileged email correspondence with our client was used by the Public Prosecution Service, read by the Public Prosecution Service, and that investigative activities were based on our emails. So as a result of that, we started asking questions. We more or less found out what happened, and we initiated a civil procedure against the Dutch state, against the Public Prosecution Service for violating legal privilege.
All right. So all different stories, of course, but all your illustrations are, of course, worth sharing today. We will discuss the topic, but before we will discuss the topic, I'm going to take a seat so that the eyes will focus a little bit more on you, Julia, because I would like to give you the floor. The principles of legal professional privilege and legal professional confidentiality aim to protect a lot of things, of course. In this we will also refer at LPPC. You will maybe explain it further on, and otherwise I will do that. But despite the legal recognition of LPPCs, the adherence of that principle by third parties, by governments, of course, concerns you, and you as the organization is Lawyers for Lawyers. This week, this report came out. You're the researcher. Could you elaborate a little bit more about this report? What is in it, and maybe share one of the most interesting conclusions that the report stated?
Yes, thank you very much. I think one thing to maybe mention before I go into the content of the report is what we actually mean when we speak about lawyer-client confidentiality. As Donatella already alluded to, there's many different terms associated with this principle. Some speak of legal professional privilege, some speak of confidentiality, attorney-client confidentiality, verschoningsrecht. So it's a principle that does not have one legal definition. However, I'll keep it a little bit closer.
Yeah, thank you.
It is a principle that is protected basically around the world. Almost all jurisdictions have some form of protection for LPPC, legal professional privilege and confidentiality, in their domestic codes. However, these definitions diverge. So they maybe have different emphasis, maybe a somewhat different scope. Maybe the kind of communications that are protected under principle differ. Maybe there'll be more focus on the rights of the client or more focus on the rights of the lawyer. And also, of course, very importantly, maybe the exemptions to the privilege, when the privilege may be waived, differ in different jurisdictions. However, what we can say is that the sort of core of this principle is generally that lawyers' communications with their clients should be protected and confidential. This means that clients should be able to trust what they say to their lawyer stays between them. Because this is very important, because otherwise the client doesn't feel free to share the information necessary that the lawyer needs to mount an effective legal defense for their client. So effectively, we're talking about a principle that protects the trust between the client and their lawyer. This principle is also connected quite generally to the principle of the rule of law. It's actually one of the key components. Rule of law, of course, in general protects, for instance, judiciary, independence of judiciary, the right to a fair trial, but also the right to an effective legal defense is part of the rule of law. We need to have fair trials before we convict people, and these people have a right to a lawyer and a right to a lawyer that can effectively defend them. Also, the principle is connected to human rights, specifically, again, the right to a fair trial and also the right to privacy and a legal defense. So this brings me to the reason why we actually wrote this report. Basically, we saw over the past 10 years already that there have been more and more instances of the principle of lawyer-client confidentiality being infringed. So this is not a new phenomenon. We are also not the first organization to report on this. For instance, already in 2014, after the Snowden revelations, Human Rights Watch reported that the United States government had infringed lawyer-client confidentiality and privilege between American clients, lawyers and their clients. So this is not a new phenomenon, but still we felt there was a need for this report because this trend has only continued in the past 10 years and has only gotten worse. There are two reasons, primarily, why we see this trend of breaching legal professional privilege and confidentiality getting worse. The first is connected to the rule of law. As I already stated, and as Mr. Pietrzak also already shortly mentioned, the principle of lawyer-client confidentiality is very closely connected to the rule of law. Unfortunately, we've seen over the past decade, a bit more than that maybe, that the rule of law is declining in a lot of countries around the world. Countries in Europe, countries anywhere else. And so we essentially see that judiciaries are becoming less independent, checks and balances are being undermined, and also that those protecting human rights, those taking on cases in the instance of lawyers, on behalf of human rights and protection of human rights, that those people are increasingly attacked and increasingly less safe. So in this context, in countries where the rule of law is less protected, we also see that the principle of legal professional privilege and confidentiality is less protected. So we see it in a sort of global context. A second reason why we see this trend getting worse is technological advancements. Salah will probably discuss that he's been hacked with Pegasus surveillance software. We basically see that over the past couple years, the technological advancements that have happened have allowed for increasingly sophisticated and intrusive surveillance software being used against human rights defenders in general, but also specifically against lawyers. So we see that actually that's, I think my main point here is that the three cases that we are discussing here today are not isolated incidents. They're part of a bigger trend of violations of legal professional privilege and confidentiality, and also part of a bigger trend of a decline in the global rule of law. So that is why it's very, very important that we're currently having this conversation and that also we keep having it, because these trends will continue and they will likely only get worse. So for this report, I've spoken to many different lawyers who have all stated, well, as probably the lawyers on this panel will state today, their frustration with the situation and their feeling of inability to protect themselves against this kind of surveillance and these kinds of infractions. So I think, the one very important finding of this report is that legal professional privilege is currently not sufficiently protected and also very importantly, not sufficiently respected. So even in countries where the rule of law is relatively okay, where maybe it has been codified, we still see that state authorities don't maybe understand or don't care to award this protection in practice. So that is, I think, the key message of the report.
Thank you so much, Julia. The final question in this panel for me is, in maybe isolated hope for a better world, that what can we do about it? Because I mean, the trend is that it's worsening, actually, if I've read the reports correctly. But we are talking about it right now. We are maybe also illustrating, and maybe we can do something about it. But that's, of course, the question that I will raise for all the panelists. I will now open up the questions via the Mentimeter. So should you have a question or remark for the panelists, they're open now. They won't be open the entire time here on the big screen. I will open it up, let's say, after 10-15 minutes, because I would like to start with our panelists first. And afterwards, of course, I will open up for you. Actually, I would like to conduct this conversation in two parts. The first part is the value of this confidentiality, and secondly, the digitalization, the digitized society, and the impact that that has on LPPC. First of all, you might remember, I say to our panelists, the sheet with the insufficient, what was it, a 4.7, I remember, was it? Do you agree on that, if you had to give a vote on a worldwide scale?
Do I agree that with that relatively low evaluation? Yes. I think it's much lower. I think it's much lower. Worse. I think when this is one of those issues that you don't appreciate is threatened until it happens to you, your colleagues, or you're actually dealing with a high-profile public case which is of interest to political authority, because then your case, your privacy, but most importantly, the rights and freedoms of your clients are very tempting for police agencies, prosecutorial authorities, counterintelligence and intelligence agencies. And lawyers are put in a situation where Donatello alluded to this, and I'm very concerned about the comment you made right now about the, and Julia also mentioned this, about the technological possibilities and challenges we're faced with. Lawyers are put in a situation where we have to compete with counterintelligence agencies in terms of technological capabilities, know-how, software, hardware. We will never be able to win that competition. We have to rely on civil society, rule of law, transparency, accountability, so legal mechanisms, procedural mechanisms, and democratic mechanisms, civil control over all these policing agencies and intelligence agencies, so that they will always know that sooner or later, if they violate the rules, wiretap a lawyer, for example, as my colleague was recently wiretapped.
What is recently?
Recently was just last year.
All right.
That there will be accountability. So we have to rely not on our ability to compete technologically. You mentioned that this is a hard sell. Or perhaps that was my interpretation. It is difficult to get people on board in protecting client-lawyer privilege. People understand that independent courts are something important for us, for all citizens.
Yes.
People understand the rule of law as a broad and important concept, but they don't see client-lawyer privilege as a critical component of the rule of law, as Julia mentioned. I would go further. I would say that it's a critical element of the procedural aspect of rights and freedoms. You can't have effective protection of rights and freedoms without access to an independent court, but just the same, you can't have effective protection of rights and freedoms without access to a lawyer who's covered by client-lawyer privilege. So this is very much an essential issue of rights and freedoms of our clients, and also our privacy. But I put that always in second place.
Allow me, Nikolai, if you had to give, I mean, a vote, a judgment, in your own experiences, has it worsened in the past 15, 20 years? Was it better when you started as a lawyer?
I asked There's always the problem of underreporting. We
Yes.
don't really know
don't
how
know.
many times we've been subject to surveillance, wiretapping, our data and metadata has been collected by these police agencies. These are by nature secret activities, but some of them come out and we can only assume it's a fraction. So, but in terms of the visible fraction that we've seen, I asked the gentleman who was the dean of the Warsaw Bar before me, during his 2 terms, how many times did he have to intervene with regard to possible violation? It was about once a year, maybe twice a year. I have hundreds of cases.
Hundreds.
And this is, of course, underreporting. So I think we can't ignore the fact that it happens at the same time as we see destruction of the courts, the tri-division of powers in Poland, the rise of populism and what's euphemistically called democratic backsliding. I think these phenomena across the world go hand in hand with a disregard for legal independence of lawyers and their client-lawyer privilege.
Salah, if you had to, do you agree on the general vote? Less than a 5, so an insufficient. Your colleague right now states it's even worse. What do you say? In your experience?
I think it's worse. I think it's worse than that, especially with my small experience as a lawyer and what we were facing unoccupied territories as lawyers. The direct measures and indirect measures. For example, me as a direct measure was the Pegasus issue on my phone, but we had daily measure against us as lawyers. For example, our clients were prohibited, for example, for 60 days of visits during the interrogation. All our visits as lawyers in the Israeli jails were under surveillance. There were no privacy between us as lawyers and our clients. For example, when we enter the courts, all our things were searched by the service and by the police. We know that we were under surveillance 24 hours as lawyers and as a human rights defender. So I think it's going worse and worse. Yeah.
Yeah. Do you see it worsening? Is it stable? It's not getting better?
I think
afraid.
it's worsening.
What do you? Why do you think? I mean, we have had a couple of arguments stated from Mikolaj saying that maybe the political and the governments and this maybe populist trend that goes around the world might interfere with that. What's your analysis? Why is it worsening?
I think it's worsening because there is no respect for the human rights values. It's only the politicians that they are looking for their interests and not for the interests of the population and the interest of law. So for this, I think it's worsening and worsening.
Okay. Going into the Netherlands, I mean, I now hope, Muriel, that you will raise the vote a little bit in the average.
You would think so. Yeah, if you would have asked this question to me a couple of years ago, I think I would have given quite, good rate.
Yes.
Yeah, but as you will understand, following our case and my experiences, and not only in our case because of this case, we received it's not an incident. That's first of all very relevant. It turned out not to be an incident, but it turned out to be a structural problem. We found out that prosecution service has a procedure in place that allows them to read privileged information, to use it, and this was something. It was completely new. I mean, this was a secret procedure.
Yes.
So we found out that this procedure was in place and that it was a structural, not a problem, and not an incident. So, but also following this case, we received a lot of emails and messages from other lawyers in the Netherlands who told us, now that we know what happened in your case, we thought about our own case, and now we
opened their
know
eyes.
it opened their eyes. Yes, so unfortunately for the Netherlands, the situation is not that good either. And we had, I mean, the reading of privileged information is one thing, but we had incidents with tapping phones, of course, recording phone calls, following lawyers during their work. So it is a problem here as well.
Let me address maybe it's not an elephant in the room, but of course I already see one of the questions goes in that direction as well, because the LPPC is of course not completely absolute. Security agency may have access to some information due to security reasons, the safety of a country. And the question here goes, should this confidentiality privilege be set aside for safety interests to the country as its citizens, for example, drug cartels? And if so, to what extent? Because of course, that is obvious the reason that it is sometimes abused or breached. Let me start in the Netherlands and then I will widen the world again.
Well, in case law, I mean, the Dutch Supreme Court set some boundaries to legal privilege. So, I mean, there are boundaries, of course. For example, if a lawyer is involved in criminal behavior themselves, legal privilege can be set aside. So, and there are other situations. There are other situations where it can be set aside as well. But I mean, safety interests of the country and citizens, and actually fighting crimes should not be a reason to set legal privilege aside. No, because that's exactly what I mean. It's there to keep the system in balance. I mean, the Dutch Public Prosecution Service, but all public prosecutors have a lot of authorities. It sets the balance, and if you set aside legal privilege too easy, there will be a disbalance, and the powers of the prosecution service will become too big.
Yeah. How in Poland, to address that also, Mikolaj, is it what was the underlying reasons why it often happens by third parties / the government? Is it known?
I'm going to do what lawyers like to do. I'm not going to answer your question directly. I'll start with something else you said. You said it is, of course, not an absolute principle. I'm paraphrasing.
Yes.
I question that evaluation, that of course. There are legal systems in which, at least nominally, client-lawyer privilege or confidentiality, secrecy, depending on the system, is an absolute. There is no legal way to violate. Certainly, this was, for example, under communist times in Poland, the principle. Whether it was respected by a totalitarian state, that's a different issue. But at least on its face, advocates' confidentiality was absolute. This has limitations now, for example, in a criminal case, and they're very consistent with what you said. By way of exception, client-lawyer privilege can be overturned. I could theoretically be summoned by a court, and the court could issue a decision weighing certain criteria, statutory criteria, releasing me from my client-lawyer privilege. That cannot concern defense lawyers' privilege, which is even under the Polish system an absolute. But if someone was unfortunate enough to receive family law advice from me, for example, that theoretically could be overturned in an exceptional situation. I would sooner go to jail. I would sooner go to jail. It is a question of deontology. I don't believe, I have very little trust in any state in terms of figuring out where that line should be drawn. There is a great potential for abuse if the powers have that right. But most importantly, if you're going to set limits where client-lawyer privilege should end, you say, for example, we were conducting a special operation. I choose my words carefully in this day and time, a special operation against terrorism. So we absolutely have to wiretap a lawyer. It's necessary for state privilege. Okay, I can imagine a situation where that is morally necessary. You're dealing with a very difficult choice. But that lawyer should, at least ex post, find out the reasoning, have the ability to file some kind of an objection or appeal and go through a court process. The situations we're talking about are in large part covert. Nobody ever finds out unless a mistake happens, unless the Pegasus system becomes suddenly available and we find out by accident because of the activities of a Canadian NGO that so many Polish lawyers, Palestinian lawyers, French lawyers, Belgian lawyers were wiretapped by what is obviously a faulty system of surveillance. Think of the non-faulty systems that are in place we don't know about. Those are the ones I'm concerned about. So we're not really talking about cases where the domestic law allows for exceptional and controlled limitations of client-lawyer privilege. Those aren't the problem.
Abuse actually this as a reason to do so.
What we're talking about are the ones where we have covert surveillance we never find out about, where we can only guess by the information that the authorities possess that they must have been listening into our conversations. And that's in fact one of the reasons a few of my friends and I ended up filing an application to the European Court of Human Rights. I'm in a situation in which most lawyers don't want to be, where I'm going to be not representing someone, but I'm actually an applicant before the European Court of Human Rights, Pietrzak and others, against Poland. Not the way I wanted to go down in history, but one of the arguments we're making is we have no way of ever finding out whether we've been subject to surveillance, and even if we did, we have no legal instrument to question the proportionality, legality, necessity of that interference. So I think the question is, right. I don't think we should be worried about those instances where we have that ability. What we should be worried about are the covert incidents of violation.
Recognize that, Salah?
Yes, maybe our situation is a bit different because we are not facing a state of law as lawyers. We are facing a military system and military courts where I was working. So all these harassments were made in the name of the security and the name of the security of the state. For example, me and other lawyers were arrested in administrative detention without charges, based on a secret file.
Without charges.
Without charges, with a secret file. This secret file stays secret between the military prosecutor and the military judge. Me as a detainee and as a lawyer, I had no right to access to this file. And this administrative detention can be renewed for more than once, and you can spend as a lawyer months and months in administrative detention without knowing why. And it's a military order that says that you are a danger on the security of the military regime. So,
and obviously you can't object to that.
You cannot object for that.
No.
Our offices were raided more than once, and our computers and our files were confiscated on the name of the interest of the security and guarding the security. So in our situation, all these harassments are made in the name of the interest of the security.
Yeah. Julia, what does the report actually say about the LPPC being an absolute, and of course in different jurisdictions? I mean, therefore I would like to use the term that you use as well as the same definition, LPPC. How absolute is it? Because I learned that it is not always not absolute. So in certain jurisdictions, at least in paper it is, in theory. What does the report say about that?
That's a very difficult question to answer because, yeah, as stated before, it depends on the jurisdiction how absolute this right is. In general, it is not considered an absolute right, so most jurisdictions have some kind of exemption, and it depends on the jurisdiction how extreme the situation needs to be for that exemption.
But those exemptions merely are terrorist, the safety of country, of the citizens, and the security of.
Of course, there's a problem where there are provisions that say for national security reasons, because maybe if you follow the news and if you look at Israel, Palestine, if you look at Poland, if you look at countries like China, a lot of things can fall under national security. So even when when the law states it can only be done in exceptional circumstances or in national security issues of large national security, this can still mean that that gives a very large exemption to this right. And I think also something that should be noted here in making this sort of balance, I guess, that we're talking about between protecting legal professional privilege and maybe national security, is that I think in recent years, sort of the value of legal professional privilege has gotten lost. It's seen as an inconvenience to fighting terrorism, fighting crime, and we're not talking so much about how this privilege actually protects our democracy and our rule of law. It's not as sexy to talk about that rather than a security agency going down on some terrorists, let's say.
Yeah.
So I think it's important in this debate that we recenter this balance and also talk about like how important this principle is has been illustrated, I think, by the cases here today.
Yes. One of the questions that, because we are, of course, elaborating this topic right now, is which judicial actions would you, panelists, consider necessary to counter or to state breaches of the confidentiality?
I'm thrilled by the question. I want to say the two first questions are absolutely to the point. This is one of the things we addressed in our application to the European Court of Human Rights with colleagues from the Helsinki Foundation and from the Panopticon NGO. There's a whole complex of things that need to take place within a procedural system, a constitutional system, to safeguard client-lawyer privilege, and in general, confidentiality of communication against abuse by wiretapping and surveillance. There's no one single element, but some of these important things are an independent body with extremely strong control instruments vis-a-vis the police or intelligence and counterintelligence or security agencies. An intelligence or counterintelligence officer has to know that ultimately any abuse will come out and there will be accountability. If these officers operate in a setting in which they are not convinced that accountability is ultimately, at one point or another, unavoidable for abuse, that abuse will happen because it's all very confidential and difficult to track. That requires a robust, strong, independent body which is represents civil society and is free from the influence of the police and secret intelligence agencies themselves. That is certainly not the case in Poland.
Was that the case in Poland
previously? No, it never was, but that comes to light when you get a populist government. It doesn't so much, it's not a needle, it's not a thorn in our side. Forgive me for this translation. There's not a thorn or a needle in our side when you have a relatively normal democratic government with all its good and bad sides. It becomes a problem when you get populists, strong-armed populists, who are very ready to abuse that. Then that lack of independent body becomes very visible. Secondly, there should be absolutely an obligation to notify anybody who's, especially lawyers, whose data, metadata, or actually their conversations or email correspondence and so on have been subject to surveillance. I understand that security concerns may dictate that that notification doesn't take place immediately. If you're going to apply surveillance vis-a-vis a suspect of organized crime, you don't want to tell them from day one, look, we'll be wiretapping you. Would you like to go to court with this before we start? That would defeat the purpose. But what you can do, and what happens in some states, is you install an instrument whereby that person is informed ex post, 2 years later, 3 years later, 5 years later, but they're notified.
There will be.
Yeah, they must be ultimately notified. That is the most critical element of the whole puzzle. No surveillance without ultimately at one point notification that they've been subject to surveillance.
It's more about the system and the governance.
Secondly, an appeal. What good is notification if you can't question the legality, proportionality, necessity of that interference in your rights and freedoms, and more importantly, in the rights and freedoms of your clients? You have to have some kind of way to appeal and to get this case to an independent court, which is going to evaluate whether the this exception to client-lawyer privilege actually took place, and whether the police or counterintelligence agencies were right in using this exceptional instrument.
Did I see a?
Yes,
Yes.
I fully agree. Yes, of course, of course. Now, I think the thing is, in the Netherlands, we have quite a good. The rules on the protection of legal privilege are okay, are good, can be better. There will be a new code of criminal procedure, and the rules will be even better in that new code of criminal procedure. From that perspective, the situation in the Netherlands is quite okay. Very relevant, of course, is that every party involved in the legal system needs to recognize the relevance of legal privilege. That's. I mean, you can have a lot of rules, but if they're not complied with, if the relevance of legal privilege is not recognized,
And actually, you say it is also in the Netherlands. It's not
yes,
generally
no,
recognized.
yes,
This privilege.
yes.
And by whom? Is it by the politicians, by society, by authorities, by
Yes, by
Officers.
authorities,
by judges?
sometimes by judges. You see, I think also in the Netherlands, there's a real urge to fight crime, and of course that's I understand that. But still, you need to recognize the relevance of legal privilege within that system, like I said, because only then system is in balance. Yeah.
Criteria. Salah, in response to this, obviously your case and story is a little bit different because, as you stated, military is not the same as civil. Which legislative or judicial actions would you then consider necessary or acceptable? In general?
I think this military occupation, feeling the impunity toward the lawyers and everything done in the occupied territories, this impunity gives them the power to do whatever you want. I think measures and sanctions must be taken and put in on the decisions maker who are taking these measures and doing these measures against the lawyers and the legal system in the occupied territories.
The digitalization and consequences of breach of the confidentiality for lawyers. What is, let's say, the most concerning in this? Because let's not go to the advantages, because I think everybody recognized them. But we are in the middle, and you actually already had a firm statement if I remember well, in your first reaction. What is the most concerning if we speak about the digitization and the increased use of, let's name, spyware and other things by the authorities? Yes.
Well, I did make mention of this once again, but I think it's just become easier. Any one of us can, if we were to disregard the law, other people's privacy, can easily locate an application, software, or even hardware to spy on other people. The technology has become very easily available, especially to states with their power, their finances, their technological know-how. So perhaps that's one of the answers we didn't provide to your earlier question. Why the escalation? It's not only an issue of rising populism and disregard for rights and freedoms, of which confidentiality is a necessary component, but it's also because the means are very available. Under communism, if the KGB or the Polish secret political police wanted to spy on my father, they would have to bribe one of his co-workers. They'd have to find a leverage to threaten that person that their child wouldn't get into a school if this person didn't provide information on where my father was getting money to provide me with Western jeans. This is real stuff, by the way. So it took effort. you'd have to actually make the effort
And now it's much easier.
to get intelligence. You would have to have a secret group of people to come in and plant a bug with a wire inside a wall, run the wire. The batteries weren't so well developed, so that would run out. It was hard. Now we all have Orwellian telemonitors. I don't know what the word is in English. We all have the Orwellian instruments in our pockets. Each one of us is carrying our very own self-spyware, and it is extremely easy for governments to do this. So once again, we shouldn't be, as citizens, but especially as lawyers, placed in a situation where we have to compete technologically, because we are doomed to fail. We have to rely on democratic mechanisms, civil oversight, procedural oversight, court oversight, and strong mechanisms of accountability to avoid impunity.
Yeah.
Because that's the only way we can be safe. If it's not Pegasus, if it's going to be different software, if it's not
Pegasus is just one, but
if it's not a mobile phone, it's going to be a laser microphone to your window. The means are there.
Allow me to go, Salah. I mean, speaking about Pegasus, what happened to you?
Yeah. Before speaking about Pegasus, just remember now that when I was released in 2018, I was in administrative detention. I decided not to have a smartphone. I just bought a small phone to get rid. 2 weeks after this, I was called by the Israeli services for interrogation. And they told me, if you will not go and buy a smartphone and they keep it with you, you will go back to administrative detention. So they are telling you directly, we need...
At least it's obvious then.
Yeah, they said it directly, we need our spy in your pockets 24 hours.
How can I say it without saying it?
What?
How can I say something without really saying it? But I mean, but you had to have you bought one.
So I bought one for avoiding going back to
Understand,
administrative detention. So in 2020, me and other colleagues remarked bizarre things happening in our phones. My camera was opening, for example, without my orders.
So that's what you were noticing?
Yes, I was noticing
strange things were happening.
So
could you give a few examples, because I don't think that everybody in the room has been spied by Pegasus in his life. So what happens with your phone?
So I didn't know before having this. I didn't really know things about Pegasus, but the camera, for example, of my phone was opening. The phone was going on apps that I didn't demand. For example, putting likes on things on Facebook or on Instagram without my orders. Another colleagues of me, his phone was calling other people without using his phone. That for us it became bizarre that our phones are doing something that we didn't order. So I contacted.
Did you immediately suspect that it was?
I didn't suspect it. It was the advice of an organization, a human rights organization, Al Haq, that contacted us and advised us to special examinations for our phones. So we were contacted by Citizen Lab, Amnesty International Lab, and Frontline Defenders, and they made the examination for our phones, a special investigation, and they discovered that since months and months, where our phones were infected by the Pegasus. By Pegasus.
Yes, by months.
Yeah.
Yes. Is there actually an easy way to discover whether you have spyware like Pegasus, but it's just one, because there are numerous in the world? There's no easy way, maybe. I know that Amnesty International has this tool.
Essentially, it's really, really hard. And that's part of the problem as well, I think, because the lawyers that I've spoken to, they've also experienced Pegasus hacking or other kinds of surveillance.
In what countries?
For instance, India, Jordan, different countries around the world.
It's widespread.
Yes, definitely. Okay. I mean, Pegasus was used in 45 different countries, and even by just Googling online, you can find names of dozens of lawyers who've been infected, and that's only the names that are on the internet out there. So I think this problem is quite widespread, you can assume. But I think also all the lawyers that I've spoken to that were infected with Pegasus said that they didn't know, they weren't able to find out about, because they were, maybe you were contacted as well, I think, by frontline defenders. And yeah, and so basically they were reached out to by Amnesty International and frontline defenders, who said, your phone number is popping up in this database that has been leaked, so we think that your phone may have been hacked. So if you want, you can send your phone to us, we will check it for you, and we will see if we can find traces of this software on your phone. So the lawyers would send their phone, it would get confirmed. But even then, it is really hard to ascertain who put it on your phone. So it's not even clear. Of course, the lawyers have presumptions because they know who they were doing sensitive cases against. So would have an interest, would have the money to buy Pegasus. So usually it's the state, but it's incredibly hard to find out about. And even if you find out about it, you don't have proof who it was. So it's a massive issue of transparency as well. And also then once you find out about it, as Mikolaj said, or maybe it's been said before, what are you going to do?
Do we also have Dutch cases?
As far as I know that the Dutch state has bought Pegasus, but I don't know that it's been used. So I haven't heard of cases against Dutch lawyers, but there have been cases in Europe.
But we know that the Dutch state, the government, so the secret services probably have the access to Pegasus
or similar software.
Or similar software, because
yes.
I mean, this is just one, but there are numerous. It is also used in Poland.
It was. We all found out about it about the same time everyone else did, and immediately we found out that several leading politicians, opposition senators, of course, opposition members, and lawyers were targeted. In fact, one prominent lawyer by the name of Roman Giertych had his who was counsel lawyer for Donald Tusk, our former prime minister, and the most important person in the opposition. His phone was subject to Pegasus. We had another of our lawyers who was working with a opposition senator. She had Pegasus. In fact, many of us who are defending judges or providing services to opposition members were somewhat disappointed to find out our phones weren't subject to Pegasus. And because it was considered at one point to be a distinction. That was something that was very prominent. It was public, but I feel it sort of muddles the issue, because the vast majority of the materials we see resulting from surveillances against lawyers don't come from Pegasus.
No.
They come from routine metadata collection. They come from routine covert surveillance, wiretapping, microphones, spyware of all sorts that are much more mundane. So of course, I think Pegasus wasn't a big deal. It was a flop because we all found out about it. The ones I'm concerned are the ones we don't know about.
Yes.
And I'm sure there are many of them, and we'll be talking about them, some of them in a few years.
Next
perhaps.
symposium, yeah. Looking with an eye on the time as well, I would like to conclude with the question: what is happening now to fight it? What can we do? Is there something that we can do? Because if it is widespread, like the report says, like all your illustrations in the countries and globally say, and even in the Netherlands, once we thought that, no, well, what can we do about it? I mean, is there something that we can do? Let me start with you, Salah. What is, in your opinion, the one or the first steps that we should take upon as lawyers or as NGOs? You say it.
I think one of the measures before developing a big strategy for defending it, we have to go back to the ancient ways of working to protect our work.
And the ancient ways are everything on paper.
No, there are measures of security that we have to take while using phones, while using internet, while using. There are measures that to defend our clients and defend our work. And I think we have to create this block of NGOs and the civil society block that can put pressures on the political makers and decisions to put them pressures to stop these violences against the lawyers.
Muriël, what is something you think that, I mean, what is, for instance, happening right now? Because also in the Netherlands, I mean, if you are aware of it, this was, of course, broadly also covered by the media. A lot of citizens didn't even know that this was happening. There's a lot of ignorance, not in their fault, but there is. So what should happen?
Well, a lot is happening right now. So I mean, this is on lots of people's radar now. So politicians, lawyers, I think judges as well. But if you ask me, what can we do or what should we do? My answer would be active and be curious, ask questions, and don't accept answers too easily, but yeah, remain curious. What happens? And be critical. Yes, because I think here in the Netherlands, for a long time we thought, well, everything's going quite all right. Legal privilege is recognized, and it turned out to be completely different. And the only way we found out is because we kept asking questions. We started a procedure. We didn't take no for an answer, and we wanted to know what's actually happening. And I think that's very important for us as lawyers.
Yes, I see a lot of, like I previously mentioned, a lot of young lawyers in the room as well. People starting their hopefully great careers as lawyers.
Are you pointing out our age?
No, I'm not. I'm just emphasizing the fact that besides a lot of experience,
only young people there, not here.
There are even younger people here in the room. And what should be actually the message to the people that are just starting and didn't have all the experience that people here on stage already have had? The first lesson actually you gave, Muriël, that be critical, don't take everything for granted. Is that a good lesson, Mikolaj?
I think I wouldn't, when I was beginning my work as a criminal lawyer, I wouldn't have assumed that I would be subject to wiretapping. I believed in the state much more. I no longer have that belief. I think your message of continuing vigilance that's the best lesson that can be taken away. Always assume you're being wiretapped. And you asked, what can we do as lawyers? What I do right now, when I begin a conversation with a client, I say into the microphone, well, okay, it's hi, it's nice to hear you, but before we start, I am now declaring to anyone who's listening in or wiretapping that this is a privileged conversation between a defense lawyer and their client. It is covered by absolute confidentiality. If you continue listening or recording, you're committing a grievous crime and you will be held accountable. And that's the spiel that I go through at the beginning of every telephone conversation, which is pretty tiring. And some clients laugh. I don't laugh anymore because I've seen transcripts of Maria Radziejowska, excellent lawyer who's now in The Hague. We're defending in a case, and just last year, she was talking with our client in a specific case 3 times about strategy. And to our surprise, at the beginning of this year, the prosecutor in the case, without so much as a sorry or I apologize or this is awkward, delivered transcripts of 3 of her conversations to the case, which the conversations concerned, as incriminating evidence. So I'm now assuming that everything we say is not secure. So I start by that declaration, because then they can't pretend that they didn't know they were listening into a lawyer. We eliminate the argument of, oh, I had no idea. Of course they know who they're listening, whose conversations they're listening to. Secondly, I think we as lawyers should do what we do best, litigate. That's why we ended up before the European Court of Human Rights, that we're much better than NGO activists at litigation. NGO activists are often better at us than public lobbying and advocacy. But this is something we as lawyers can also do, especially in bar associations. Public advocacy and lobbying, political lobbying, and equating judicial independence with client-lawyer privilege. These are two equal values in a democratic, liberal, constitutional arrangement. And that's something we can do. And finally, this is the toughest one and the most important one, education. We should all be regularly in schools, in universities, especially not in legal circles, but the polytechnics, the medical schools, among educated professionals, explaining these values, explaining why they are critical to the whole democratic system. And that requires time, dedication, and many years of work.
Yeah. And what everybody here can do, send the registration of this seminar to a non-lawyer in your I mean, in the acquaintances that you have, so that you, because otherwise, I mean, with all due respect for the numerous people that are here present and also the virtual people, I don't think that you have to explain it to a lawyer. You will understand this principle, but the ignorance is besides that. So there's room for improvement. The report can be downloaded on the site of Lawyers for Lawyers.
It's on our website.
It's on the website, so go there. Thank you so much, everybody here. Big round of applause. Salah, ladies and gentlemen. Julia, thank you so much. Muriël and Mikolaj, thank you. And for now, ladies and gentlemen, there is a short break foreseen. What is a short break? That's 15 minutes. We will remain here. I think that the bar will be opened over there and here. After this short break, we will subsequently continue with a great award ceremony, the Lawyers for Lawyers 2023 award ceremony. So please be on time. 15 minutes from now, see each other back here in room. See you. So, ladies and gentlemen, welcome back. And we are now moving to the award ceremony. I will subsequently, coming up, give the floor to the member of the Lawyers for Lawyers jury, the winner of the past award, and subsequently we will have here at the table the acceptance speech of the winner of the 2023 award. But first, we are listening to the opening remarks of the next speaker, Professor Sutterwave, and an organ playing in the background to raise the tension. Professor of Clinical Law at the New York University School of Law, where she directs the Global Justice Clinic, and she also serves as a faculty director of the Robert and Helen Bernstein Institute for Human Rights and the Center for Human Rights and Global Justice. So, ladies and gentlemen, we are going to listen to Professor Margaret Sutterwave.
Thank you for the honor of joining you. My name is Meg Satterthwaite, and I am the Special Rapporteur on the independence of judges and lawyers. This is a very special event in which lawyers recognize the crucial and important role of lawyers for protecting human rights in the world. I'd like to talk a little bit about why the independent functioning of lawyers is so crucial. Around the world, too few people are able to access justice. 2/3 of the world's population, around 5 billion people, lack access to justice for everyday legal problems. At any one time, 1.5 billion people have justice problems they can't resolve. Lawyers play a key role in helping people to resolve legal problems. And when human rights and fundamental freedoms are on the line, it's even more important that these people have access to appropriate legal assistance to identify, articulate, and protect rights. Lawyers are involved in all types of justice problems, from assisting communities to challenging infrastructure projects that threaten massive environmental harms, to supporting workers who've been victims of harassment or discrimination to file complaints, to seeking protective orders for individuals experiencing violence and abuse at the hands of their partners. When people are accused of committing a crime, access to legal representation is a key human right in itself. The involvement of lawyers helps to ensure that criminal proceedings are conducted appropriately, that punishment and detention are not arbitrary, and that people are protected from torture and other degrading treatment. In order to perform their vital function in society, lawyers have to be at liberty to act in the interest of their clients and in accordance with their professional duties, free from interference by the state. They should not be threatened with sanctions for actions that they take as part of their professional role. They should feel confident that they're playing their part within an impartial legal system, which exists to uphold the rule of law. But in many places, this impartiality is eroding, with attacks on the independence of judges and lawyers and prosecutors. The World Justice Project reports that 2022 was the 5th year in a row that the rule of law declined in most countries, with checks on government power falling in 58% of countries, and respect for core human rights and freedoms falling in 2/3 of the countries. We've seen a trend toward democratic backsliding and rising authoritarianism worldwide. Powerful actors have a strong interest in capturing and weakening systems that would otherwise provide a check on their power. As a central part of that system of checks, lawyers are under threat worldwide. I'm extremely concerned about widespread and increasing efforts to target lawyers for their work. This includes both their professional work as lawyers and their work as human rights defenders, fighting to uphold the rule of law in their countries. I'll speak today about two particular forms of attack. Those are acts of violence and the misuse of the legal system to criminalize lawyers for doing their jobs. In November 2022, I wrote to the government of Guatemala regarding the case of Virginia La Parra Rivas, former chief prosecutor of the Special Prosecutor's Office Against Impunity. Ms. La Parra has been arrested and indicted for abuse of authority and usurpation of authority. The proceedings against her have been characterized by violations of due process, including undue delays and excessive use of pretrial detention, and she's been detained in conditions that put her health and safety at risk. In a letter to the officials, I expressed concern that proceedings against her would be reprisal for the anti-corruption work she had carried out in her role as a prosecutor. In December 2022, I joined with colleagues to write to the government of Zimbabwe regarding Douglas James Coulthart, a human rights lawyer who since 2019 has repeatedly faced intense harassment in the course of his regular work as a legal practitioner, according to information I have received. Mr. Coulthart has allegedly been beaten, detained, charged, and prosecuted for exercising his professional duties on more than one occasion, including for accompanying his clients and filming peaceful protests, trying to visit clients in custody to provide legal assistance, and questioning the legality of police searches. Tragically, some lawyers have paid for their commitment to the rule of law and fundamental rights with their lives. In January of this year, Thulani Maseko, a prominent lawyer and human rights defender, was assassinated at his home. In 2014, Maseko had been convicted and sentenced to 2 years imprisonment for contempt of court for allegedly having violated and undermined the dignity, repute, and authority of the High Court of Swaziland by writing and publishing an article critical of a judge's handling of a criminal case. I joined with colleagues writing to the government of Eswatini, expressing the fear that this brutal murder was carried out in direct retaliation for Maseko's human rights work and his leadership role in the pursuit of the full protection, realization, and fulfillment of human rights in Eswatini. But the story doesn't end with attacks on lawyers, because despite the many dangers and violations that they face, lawyers are fighting back. They're fighting back by continuing to carry out their professional duties in the face of threats and intimidation. And they're fighting back by speaking out against rights violations, by representing their fellow lawyers when they fall victim to reprisals. I'm honored to pay tribute to this year's nominees for the Lawyers for Lawyers Award, who've made significant contributions to the protection of the rule of law and human rights in the face of unimaginable challenges. Congratulations.
And now, ladies and gentlemen, let's hear from the jury for the presentation of the jury reports 2023. I would like to invite here on stage Egbert Meijer, member of the Lawyers for Lawyers jury, with a big round of applause, ladies and gentlemen. Wie is hier? There you go.
Ladies and gentlemen, I was just warned that I'm no longer allowed to say ladies and gentlemen, but to say his, her, and leave it. I'm going to do a magic trick. On the program, it says the report of the award jury as read on the 11th of May, 2023. But if I'm going to read it, this will last about half an hour. So the magic trick is that I'm indeed only telling you a few things of the report, but the whole report, well, at least you can read. And as you can see, the jury consists of Kees Flinterman, Professor Kees Flinterman, former member of the United Nations Human Rights Committee and Professor of Human Rights in Maastricht. Ghana Samkalde, Dr. Ghana Samkalde, I should say, lawyer Prakke d'Oliveira, human rights lawyers, Professor Emeritus Jenny Goldsmith, former director of the Netherlands Institute for Human Rights at Utrecht University. And my name is Egbert Meijer. I'm a former judge in the European Court of Human Rights, elected in respect of the Netherlands. Then the jury report. 23 individual lawyers and 3 lawyers collectives. In total, 26 nominations for the Lawyers for Lawyers Award this year. 7 nominees from Africa, 7 from Asia, 9 from Central and South America, and 3 from Europe. At first sight, it's not an entirely surprising geographical distribution. And at the same time, the jury is aware that many more brave lawyers could have been nominated. For example, the names of certain lawyers from European countries where at this moment a lot is happening in relation to rule of law are missing. Lawyers known to be taking action against autocratic governments under difficult circumstances. Governments that seem to have forgotten that the actions of a democratic majority are indeed limited by human rights and the rule of law. There's also a lack of nominations, with a few exceptions, from some French-speaking African countries where really worrisome situations occur and examples of brave lawyers who oppose them are known. 23 individual lawyers, 12 of whom are women. 23 lawyers, the youngest of whom is 25 and the oldest is 72, with many nominees in their 30s and 40s, most of whom having families whose lives are also affected. 26 nominees who in their professional capacity have made important contributions to the promotion of the rule of law and the protection of human rights. In almost all cases, with proven major personal risks, sometimes resulting in, so far, only harassment, suspicions, and public threats, and in quite some situations, highly disturbing government reactions, such as attempts to disbar them or make the legal work de facto almost impossible. Sometimes prosecution and sentences to indeed sometimes long prison terms or even deportation. 26 nominees, and preferably after reading the nominations, the jury would have rewarded the Lawyers for Lawyers Award to a large number of these nominations, if not all. But we can't. We had to find one winner. But like in previous occasions, I must admit, it's almost impossible to assess the bravery shown in the professional practice of the nominees on a scale. The jury waited for a long time, and in the end, we reduced the list of candidates to 3 people. And subsequently, the jury unanimously determined which candidate should be awarded the Lawyers for Lawyers Award 2023. Before I'm going to say a little bit about these 3 names, we'd like to mention 3 other nominees with honor. And the first one is the oldest nominee, the 27-year-old Indian lawyer Parvez Imros. He indeed deserves a separate mention for the impressive way in which he has bravely stood up for human rights throughout his working life, even under sometimes challenging circumstances. His work reaffirms that even in a relatively stable democracy, human rights cannot be taken for granted. That is also why he has been nominated, among others, by the International Federation for Human Rights. The second and third are Belarusian lawyers, Alexander Danilevich and Vitaly Braginets, nominated by the laureates of the Lawyers for Lawyers Award 2021. Also, after the Russian invasion of Ukraine, both lawyers have bravely and at the expense of their own freedom and security focused on human rights in their country. And then say the numbers 2 and 3 are the Tajikistan-born Manukher Kolinadzadov, I hope I pronounced it a little bit all right, who stood up as a lawyer for the Pamir minority and who has since been sentenced to 15 years in prison for his work. And the other is Bufete Juridico Justitia para los Pueblos from Honduras. This is a lawyers collective that, among other things, stands up against arbitrary detention of the human rights defenders and indigenous people. The members of that collective also run a serious safety risk with their work. The jury's choice eventually fell on Guatemalan Claudia González Orellana. She was, I can tell you, nominated twice. And I won't read the whole report on her, but does this. After 36 years of internal warfare, Guatemala struggled for democracy and installed an international commission against impunity. We just heard it mentioned also in the previous speech. And from 2011 to 2019, a period known globally for unprecedented accountability for corruption in Guatemala, Claudia González Orellana was a prosecutor with that International Commission Against Impunity. They successfully prosecuted high-level government officials, Supreme Court and Congress members, and other members of organized crime. This work threatened the interests of a corrupt network, the so-called Pacto de Corruptos, a group of economic, military, and political elites. In September 2019, the center had to close down. And the team of lawyers faced attacks by the individuals previously investigated. Many fake cases were created to criminalize lawyers, prosecutors, and judges. And there was Claudia González. And I just read one of the recommendations about her. Her valor in defending so many colleagues is not only that she does so in a scenario of so much hostility, violence, and at personal risk to herself, but also the fact that for more than 20 years she has worked in the defense of human rights and the promotion of the rule of law, including at the General Prosecutor's Office, the Ombudsman Office, and the Guatemalan Civil Society Organization's Institute of Comparative Studies and Criminal Sciences. By appointing Claudia González Orellana, winner of the Lawyers for Lawyers Award 2023, the jury wants to highlight the important work of a lawyer who has bravely represented human rights defenders at high cost to her own personal life and safety. Despite the risk of arrest or physical harm to Claudia and her family, the submission to online harassment, threats, intimidation, and the risk of persecution, Claudia bravely continues her work in order to protect human rights and the rule of law. So it's Claudia González Orellana, the winner of this award.
Thank you. Thank you so much. And to announce, well, the announcement has already been made, but to actually hand over the award, I would like to give the floor to last year's winner, the last winner here on stage, human rights lawyer, defended political prisoners, human rights defenders, and journalists from Belarus, Lyudmila Kazak, with a big round of applause, ladies and gentlemen.
Dear ladies and gentlemen, dear colleagues, thank you for this opportunity once again to be part of this prestigious Lawyer for Lawyers Award ceremony, which unites lawyers from around the world for their contribution for the rule of law and human rights. Using this unique opportunity, I would like to briefly describe the situation in the Belarusian legal profession, which has significantly changed since the fall of 2021, when my colleague Maxim Znak, now serving 10 years sentences in prison for his lawful activities as a lawyer, and myself were awarded the Lawyer for Lawyers award. As a background, since the 2020 presidential election in Belarus, which took place in August 2020, Belarusian lawyers who have worked on politically sensitive cases have been under unprecedented pressure from the Belarusian regime. After 2 years and a half since the election, the pressure on lawyers is now only increasing. As of today, the number of lawyers deprived of their right to practice law for politically motivated reasons has exceeded 100 people. More than 300 people ceased the practice of law in connection with legislative change on the bar, which established strict state control at all levels and de facto eliminated the independence of legal profession in Belarus. Today, the state authorities continue to intimidate lawyers and create problems for them to carry out their professional activities in order not just to target certain individual lawyers, but rather to affect the entire legal community. Threats to personal security, including arbitrary detention, arrest, and criminal prosecution, are increasingly used along with the already familiar mechanisms for arbitrary deprivation of the right to practice law. When I'm giving this speech, at least 8 Belarusian lawyers have been prosecuted and are in custody on politically motivated ground. Vitaly Braginets and Alexander Danilevich, who were nominated for the award by Belarusian lawyers, were recently sentenced to 8 and 10 years of imprisonment for lawfully exercising their professional activities. 2 more lawyers prosecuted for the alleged crimes against the state are currently on trial and with no doubt will face long prison terms. Literally today, a court in Minsk sentences my colleague Anastasia Lazarenko to 6 years in prison for taking part in peaceful democratic protest. On 21st of March 2023, sex lawyers who provided legal assistance to the well-known political prisoners Maria Kolesnikova, Viktor Babaryka, and my colleague Maxim Znak were detained at once. As a result of this organized attack, 5 lawyers were forced to stop practicing law, and their clients were left without access to lawyers. This clearly shows another goal of repression against lawyers, which is not only to put pressure on lawyers themselves, but rather to deprive their clients of this right to legal representation. As a consequence, for the past several months, lawyers had not access to their clients, to political prisoners, including Maxim Znak, Maria Kolesnikova, and Viktor Babaryka. Further, Viktor Babaryka, who was the main opponent of Alexander Lukashenko at the 2020 presidential election, was allegedly heavily beaten in the prison and ended up in hospital. His current location and state are unknown. Thus, Belarusian state not only fails to fulfill the obligation to guarantee lawyers the performance of their professional duties in a safe environment, but rather actively creates threat to their personal safety. Belarusian National Bar Organization, whose main task is obviously to protect lawyers, in practice was not only unable to resist the destruction of the legal profession, but also actively assist the authorities in depriving lawyers of their right to practice, demonstration complete merger with the Ministry of Justice and turning into its structural unit. In line with the above, some of the Belarusian lawyers who were forced to flee Belarus due to threats to personal safety recently established an independent association of human rights lawyers designed to provide assistance to repressed lawyers and aiming to build an independent bar association in future Belarus, in accordance with the internationally recognized standards of the legal profession. Therefore, on behalf of all Belarusian lawyers who faced the repressions, it's a great honor for me to recognize and congratulate Claudia González Orellana, the winner of the 2023 Lawyers for Lawyers Award. As a true human rights defender, Claudia remains in Guatemala, honestly defending her colleagues and contribution to the rule of law, even being at risk of prosecution. Her case clearly shows that human rights defenders are at risk all around the world, but despite the threats, they continue to honestly do their job. This is exactly what our profession is about. Thank you for your attention.
Thank you.
The text should be somewhere there, but
It was here.
it was here. I think that
Someone takes.
I think that Ludmila might take. No, oh, it's not. All right, it is somewhere. So we will find it anywhere. It has been. Oh, there it is. The jury. The jury has it. Okay. So, ladies and gentlemen, give me this. Yes, please. There you go. The winner of the 2023 Lawyers for Lawyers Awards, Claudia González Orellana. She will do it, of course, in Spanish. It will be translated here directly in English. So, ladies and gentlemen, a big round of applause. A usted.
Buenas tardes. Quiero agradecer a muchas personas por este premio, pero quiero comenzar agradeciendo a Lawyers for Lawyers por este honor. Y a ustedes por estar aquí escuchándome. Quiero decir que recibo esta distinción con humildad, con una gran responsabilidad y porque recibo esto en nombre de todas las profesionales del derecho que trabajan todos los días para defender la dignidad de las personas en Guatemala. Quiero aprovechar unos minutos para contarles un poco sobre la situación de Guatemala y tomarme la libertad para pedirles que sigan apoyando a abogados y a colegas que asumen riesgos inimaginables para defender la dignidad de las personas y un Estado de Derecho. En 1986, cuando Lawyers for Lawyers se fundaba oficialmente, en Guatemala empezaban sus pasos para transitar a la democracia. Ese año entró en vigor nuestra Constitución y tomó posesión un nuevo gobierno elegido democráticamente. Llegar a esos momentos de nuestra historia no fue fácil. El camino estuvo transitado por incontables mártires. Muchos colegas perdieron su vida por ejercer la profesión. En un pasado no muy lejano, plantear algo tan sencillo como un habeas corpus podría haber sido una sentencia de muerte. Del sacrificio de nuestros colegas aprendimos y sobre todo entendimos cuál es el sentido de ser abogados en un país como Guatemala. En mi caso particular, tuve el enorme privilegio de iniciar mi primer trabajo en la Oficina de Derechos Humanos del Arzobispado de Guatemala. Allí tuve el honor de compartir con Monseñor Juan Gerardi, quien trabajó incansablemente en defensa de los derechos de las poblaciones indígenas, de los campesinos y de los más vulnerables, y por la dignificación de las víctimas del terrorismo de Estado. Monseñor Gerardi siempre me decía que Guatemala había tenido demasiados mártires y que el país no necesitaba más. Aunque él era muy consciente del riesgo que implicaba defender derechos humanos en Guatemala, no estaba interesado en ser un mártir más. 2 días después de la publicación de un informe del proyecto de recuperación de la memoria histórica, donde se documentaron más de 54,000 violaciones a los derechos humanos durante las dictaduras militares, Monseñor Gerardi fue brutalmente asesinado. Él, como muchas personas en Guatemala, solo querían un mejor país. Recordar la voz de Monseñor Gerardi me llena de nostalgia. Hace un par de años se estrenó un documental sobre su asesinato y la investigación que le siguió. Cuando yo lo vi junto con mi hija, no pude evitar pensar que hoy Guatemala de muchas formas es un país muy distinto al que conoció Monseñor Gerardi. Sin embargo, muchas otras es muy similar. Soy parte de una generación de abogadas que crecimos y nos formamos en un país marcado por la guerra y el autoritarismo, pero que hemos ejercido la profesión en tiempos de paz. Me reconozco como parte de un grupo de abogadas que creemos que la lucha por defender la dignidad de las personas y el Estado de Derecho vale la pena. Por eso siempre he aceptado como mi vocación el reto de combatir la corrupción, la impunidad en el país, que agoniza por la desigualdad, la pobreza y las injusticias cotidianas. En el año 2011 me incorporé al equipo de trabajo de la Comisión Internacional contra la Impunidad en Guatemala, CICIG. Allí, junto a un grupo de colegas nacionales e internacionales, hicimos nuestro trabajo de investigación, de combatir y desarticular grupos organizados, de crimen organizado, incrustadas en las instituciones del país. En palabras del ex jefe de la Fiscalía Especial contra la Impunidad del Ministerio Público, quien ahora se encuentra en el exilio y es uno de mis defendidos, podemos decir, vimos el crimen a los ojos. Por un tiempo estábamos convencidos de que conducíamos un tren imparable cuyo camino era la esperanza de un mejor país. A través de las investigaciones de CICIG en las que participé, tuve el privilegio de hacer un pequeño aporte a esos años en que el pueblo de Guatemala recuperó su capacidad de soñar un futuro para todos y todas. Hoy, esos años parecen ser un espejismo. Los grupos de intereses que fueron afectados por la labor de decenas de jueces, fiscales, periodistas y activistas han buscado desmantelar el Estado de Derecho y cobrar venganza. Me estoy muy triste de contarles que en Guatemala actualmente vive la peor erosión de sus instituciones democráticas desde la transición de 1996. Después de la salida de CICIG ha ocurrido un proceso de cooptación del sistema de justicia. Esto ha resultado en detenciones arbitrarias, procesos penales espurios y, en general, la criminalización de operadores de justicia. Al día de hoy, esta ola de represión institucionalizada ha empujado al exilio más o menos a 100 personas entre jueces, fiscales, periodistas y activistas de derechos humanos. Virginia La Parra, Samari Gómez, Eva Xiomara Sosa, Leila Indira Santizo son algunas de los nombres de valientes fiscales y abogadas que han sido víctimas de criminalización y detenciones arbitrarias. Casi todas de ellas son mis defendidas. Esto no es otra cosa que la venganza por haber ejercido sus cargos con dignidad y decoro. Aún en estas condiciones tan difíciles, la defensa legal de mis colegas criminalizadas es un derecho básico. Con un grupo de abogadas, jóvenes, valientes, y muy entusiastas hemos asumido la responsabilidad de defenderlas, siempre con el acompañamiento de organizaciones de derechos humanos y personas que nos acompañan en cada paso que damos. Sin embargo, después del martirio de Monseñor Gerardi, defender los derechos humanos en Guatemala continúa siendo riesgoso. Mi colega, Leili Santizo, por ejemplo, fue detenida arbitrariamente tan solo por haber logrado una decisión favorable en los tribunales. Virginia La Parra, que aún se encuentra en prisión, enfrenta un segundo proceso penal. Del mismo modo, otras colegas han sido objeto de procesos penales espurios y órdenes de captura únicamente por atreverse a defender a quienes buscaron un país más justo. Junto con mis colegas y mis defendidas hemos sido víctimas de actos misóginos y discriminatorios, todo con la aquiescencia, complicidad y participación directa del personal del sistema de justicia. Quienes somos mujeres, abogadas, somos también madres, somos esposas, somos hijas, somos abuelas, vecinas, cuidadoras, somos sanadoras. Por esa razón, hago un especial agradecimiento a mi familia. Salir a enfrentar un contexto tan difícil y riesgoso es mucho más fácil, porque mis hijos y mi esposo me acompañan, me cuidan, me quieren. Sin ellos, yo no pudiera estar aquí haciendo mi trabajo. Gracias a ellos, que los amo muchísimo. Construir un país justo requiere necesariamente del Estado de Derecho. Hoy esto no existe en Guatemala, pero eso no significa que no pueda existir. Por lo pronto, el rol de las abogadas en mi país es forzar que el sistema de justicia funcione. Termino citando con nostalgia y cariño a Monseñor Juan Gerardi, que cuando presentó el informe del proyecto de recuperación de la memoria histórica dijo: este camino estuvo y sigue estando lleno de riesgos, pero la construcción del reino de Dios tiene riesgos, y solo con sus constructores, aquellos que tienen la fuerza para enfrentarlos, siguen. Muy agradecida por el premio. Gracias.
Enhorabuena para todos. Gracias. And with that marvelous speech, gracias, we conclude almost the formal part of this seminar, of course. Not before I would like to emphasize the next sheet, how to support the Lawyers for Lawyers Association, of course. There are several ways. First of all, you can scan for the second time the QR code. That's one of the most easy things. You can become a Lawyer for Lawyer volunteer. You can participate in the letter writing campaigns, support with time, with money, time, and dedication. Everything, of course, is possible, and it is much needed. So very much appreciated if you are not already a volunteer or one of the contributors for the Lawyers for Lawyers Association and movement. And with that, I thank you all, of course, all the speakers, the winners of last year and this year, and of course you, that you freed your agenda to come here. And on behalf of the Amsterdam Bar Association and of course Lawyers for Lawyers, a good evening ahead. And I think that the social drinks are happening, but not in the moment because the president is here. So what's happening?
There's lots of people to thank for this event, especially people from the Amsterdam Bar Association and of Lawyers for Lawyers, of course. I look in this direction. Thank you all very much for all the work that you did to make this event possible. Thank you to the jury, of course, for your very important work. But these flowers are for you, Donatello.
For me?
Yes.
Wow.
Thank you so much.
Thank you. Of course, very happy with it. Right now, the informal part starts. Bar is open. Goodbye.